I'm Catherine Lehman. I am the Executive Director of the Edley Center on Law and Democracy here at the Law School, and I am delighted to be in conversation today with Catherine Fisk, who is the Barbara Nachtrieb Armstrong Professor of Law here at the Law School, and also is the author of the article that we'll be talking about, which I commend to everybody for reading, which is Democracy and a Nonpartisan Civil Service, published this fall in the Arizona Law Review. Just to say a little bit more about Professor Fisk, she's written 6 books, 2 of which are coming out in this coming calendar year, which is to say, what a busy year. Thank you. And many articles in addition to this one, and in addition to teaching here at the law school, for which I am very grateful. In her prior life, she's a former Fed. She worked as an attorney in the United States Department of Justice, and also before turning to academia, was a union-side labor lawyer, and not surprisingly teaches labor law here at the law school. So I want to jump into this conversation and also just acknowledge that in addition to law students here with us, which is a pleasure and a delight to see, we also have a bunch of former Feds. And so this conversation is quite personal for those of us who are thinking about a next career in government possibly, and also for those of us who have loved a career in federal government. So we just want to acknowledge and say thank you to all of you for that too. So to get started, in your amazing article, you detail more than 130 years of having statutory protections for a nonpartisan civil service, and what it means to have that. You also explain that not persisting with that is a flagrant First Amendment violation, which I'm looking forward to hearing more about. But I want to start with the history that you detail about how we got to a nonpartisan civil service and why it matters, if you wouldn't mind starting there.
Hello, everyone, and thank you for spending your lunchtime in the weeds of federal civil service law with us. The United States first adopted civil service protections for federal employees in 1883. If you've been watching the Netflix show about James Garfield, the statute was enacted after he was assassinated by a disappointed and apparently deranged office seeker who was angry that his work on the election didn't result in him getting a job. The problem was that he felt he deserved it for his political work. And it was that problem that this law addressed when it was enacted in 1883 and revised over the years, and then thoroughly overhauled in the Civil Service Reform Act of 1978, which, like the original one, responded to the alarm about corruption among some federal civil servants in the Nixon era, and in particular, Richard Nixon's unsuccessful effort to eliminate civil service protections so that Democrats in the federal civil service could be fired and be replaced by Republican loyalists. The civil service protections are complex, but as revised in 1978, the basic idea is that the vast majority of the roughly 2 million federal civilian employees, I'm not talking about military, are hired based on merit, are compensated and promoted based on merit, and cannot be fired except for cause, and that they have procedural protections entitling them to challenge a firing as not being for cause. And those challenges ultimately go to an agency created by the statute known as the Merit Systems Protection Board, and then eventually from there to a federal court. So the whole point of this system was to ensure that people's political activities, or lack thereof, were not the basis for firing. And I want to say I started writing this article in December last year, after I handed in my grades, thinking it would be an op-ed when I was alarmed by what Trump was threatening to do, and then it grew in complexity, as they did far more than I had thought they would possibly do to attack the civil service, but also because, and I have to mention this now, my mother, after graduating from Berkeley in 1947, proud of her Phi Beta Kappa Key and her degree in international relations and political science, I have a picture of her standing on the steps of International House where she lived as an undergraduate, went off to Washington to work for a federal agency, trained for this particular job involving international relations. She was actually in the clandestine service of the CIA. She was in spy training, believe it or not. She was a Russia specialist and spoke Russian. She hung around with Russian emigres in Washington, D.C. in the late 1940s and early 1950s to perfect her colloquial Russian, all of which was to enable her to go to Berlin to work for the United States. And she saw that as sort of protecting democracy in Europe against various totalitarian threats. However, somebody thought she might be a communist, A, because she was a liberal Democrat, and B, because she spoke Russian and was hanging around with Russians. Well, guess what? Any Russian emigre who was in Washington, D.C. in 1951 had fled Russia in 1918, 19, 20, 21, and not after, basically, because they were anti-communist, not pro-communist. But the people who were in the midst of a communist panic in the late 40s and early 50s were too ignorant about history or politics to know that. She got fired. I have all her letters. They are absolutely heartbreaking. And I will say, in honor of our former federal civil servants in the room, being fired without cause and without process is a traumatic experience. My mother never recovered from it. She died when I was young, and that was really sort of the end of her, getting fired from that job was kind of the end of her real faith in democracy. I can only imagine the devastation that some people in this room and thousands and thousands of others have experienced. It is a terrible way to run a country by any possible measure, because it puts ignorant and untrained people in place of those who actually are good at their job, makes people afraid, and as the Trump administration is candidly admitting, that is the point.
Yeah, I really appreciate the ways that your article humanizes the experience of losing people who are hired and supported in their work because of their skill, and also the degree to which fomenting distrust as the human cost that you describe for your mom, among others in the article, and also the democracy cost, the cost of confidence in government, the cost of confidence in an effective system for governing. And you note in your article some scholars who say that creating this arbitrary spoils system may lead to an exodus of the government's more skilled and mobile employees, and also may discourage persons who are at the start of their careers from entering government. And so, those are very concrete costs to the ways that we do the work. You also detail a pretty extensive history of corruption before we actually got the laws that guaranteed the nonpartisan civil service. And if you wouldn't mind talking about that, and also your view about whether it's inherent that corruption will follow when we don't have that nonpartisan civil service.
Right. Yes. So in the first sort of 30 years under the new Constitution, it was not first of all, the federal government was tiny, but second, it was not generally the norm that an incoming president, even when the president was of the opposite party of the person they replaced, would fire federal employees. But when Andrew Jackson was elected president in 1828, for a mix of reasons, some good and some not so noble, he thought that it was important to replace federal employees. in part because he didn't think that the job of a federal civil servant required a lot of skills, and so it was about democratizing, at least among white men, to get rid of the elites and replace them with the common man. And in part because federal civil employees became part of the engine for getting Jackson and his successors elected and reelected. Their labor on political campaigns was crucial, actually, in building the political parties of the early mid-19th century. But what it led to was, first of all, political turnover whenever the party in control of the White House switched, which was incredibly disruptive to governance. And second, rank corruption, people paying to get hired into a position, corruption in government contracting of a huge scale, which proved to be deeply problematic during the Civil War, when government actually needed reliable contracts for war material and people who were skilled at their jobs. Lincoln didn't try to touch the system because he was focused on the war and because it sort of maintained a kind of a political compromise during the war years. His successors in office, Andrew Johnson, Ulysses Grant, didn't care. They were beneficiaries of the corruption. And so people in both political parties, former Confederates or even current Confederates, John Calhoun, Joseph Story, names you've heard of, who didn't agree with each other on a lot of things, all agreed that corruption in hiring, promotion, and government contracts was undermining the quality of governance. And so Garfield, who was a reformer and was elected as such, thought we would improve the quality of governance, which was crucial as industrialization and the capacities of the federal government were expanding in the 1880s. It was important to get good people in those jobs. Theodore Roosevelt, before he became president of the United States, had been the head of the Civil Service Commission that was established by the 1883 legislation. That was the first civil service law. And really it was all about getting rid of corruption and political considerations. For a very long time, nonpartisan civil service was something that the parties could agree on, even in periods of time where there was tremendous conflict. In the New Deal era, when lots of college-educated people went into federal jobs at the time, including women who previously had been excluded, people of color who had been, especially black people, who had been in federal civilian employment until the administration of Woodrow Wilson, who was deeply racist and purged black people from the federal civil service. But in the 30s, jobs opened up for women, for black people, for Jews who could not otherwise have found comparably interesting jobs. But the Republicans, no fans of Franklin Roosevelt, felt that this influx of college-educated people and people who were otherwise outsiders was really an effort of the Democrats to fill the government with their supporters, and enacted a statute known as the Hatch Act in 1939, which broadly prohibits political activity by federal employees on the job. It's being violated right and left in the current administration. Also fairly broadly prohibited partisan political activity by certain federal civilian employees off the job, which was essentially a prophylactic move to ensure that people weren't covertly doing what the civil service law prohibited. And for a very long time, there was a political consensus that the civil service law and the Hatch Act promoted good government. And part of the reason for that, I discovered when I did a deep dive on the very substantial empirical literature about the effects of civil service laws, both in the United States and in countries around the world, is that nonpartisan, merit-based hiring, promotion, and protections against political firing are associated with, in ways that social scientists believe they are the causal factor of every measure of good government that you can think of. There are dozens of empirical studies. One, for example, done by our own Professor Abeyaneja, who is
Down over there, just on the other side of the podium.
Oh, there he is. Hello. Sorry, I couldn't see you. Who found with his co-author, do you want to state the finding of your article about the Postal Service?
You'll do it better than I will.
Absolutely not true. He is an economist by training and did an incredibly ambitious empirical study of the effect of civil service protections on the U.S. Postal Service in the first decade and second decade of the 20th century, finding that civil service protection for postal workers improved the efficiency of the Postal Service, accuracy and speed in delivering and processing mail. So his study, there are many other studies using U.S. states as an example. Some states have eliminated civil service protection, basically for the same reason that Trump wanted to. The governor, a Republican governor gets elected and is concerned that too many state employees are Democrats and are hostile to the governor's policy agenda, and so therefore makes state government employment at will, meaning they can be fired for political reasons. And the studies of that, whether it's survey studies or others, have found no great increase in ability, efficiency, satisfaction with government service. And then there are a lot of studies done overseas showing that political considerations in hiring and firing reduce the quality of government service. Really what they increase, study after study finds, is corruption.
So that leads to the question, do you think that's inherent? I mean, the studies have shown that they have. Do you think that it's a necessary follow-on?
I mean, it's out of my expertise to say cause and effect. I am not a quantitative empirical social scientist like Professor Aneja. He should answer this question. But my look at the literature in political science, public administration, has convinced me that there are so many studies showing that eliminating civil service protection causes corruption. I conclude that there is a causal relationship and that we will see an increase in corruption and a decline in competence in federal civilian employment as a consequence of what the Trump administration is doing.
Yeah, and just to dial back a bit to you picked up on. I want to pick up on two strands of what you described. One is a little bit more of the history, and just to make sure that we're all holding in the room. That you talked about your mother's experience in the 1950s and in the communist era. But just to say it, your mother was very far from alone. There were a lot of government workers who were accused of communist sympathies, and so therefore lost jobs. In that time, and also you mentioned one that was two more. That one of which was news to me to read about, that were waves, but there were government workers were fired based on their views on interracial marriage. Not a huge surprise for me, but also on female chastity, which did come as a little bit more of a surprise that was a job loss driver in our history. But and then you were just describing. You were just talking now a bit about the history about using federal employment as a path to middle class for sectors of our society that haven't always had it, and I think we ought to take a look at the race impacts now and the sex impacts now of the job loss that we are living in this time too. And I don't know if you want to speak to it or just want me to opine in my views, but.
Well, Catherine actually has a lot of data which doesn't surprise anybody who knows about federal civilian employment, that these ongoing firings are disproportionately affecting Black and female civil servants.
Yeah, so just to share it so that we all have these data, that turns out that Black people are about 18% of federal employees, or have been up until this time, and that compares to 12% of the workforce generally. So, choosing now to decimate the workforce is a choice to render greater job loss in a Black community. And then, you were mentioning the ways that a path to the workforce had been understood and has been understood, a path to middle class for Black workers. Also, just to commend to our audience, the New York Times in August had, I thought, a very compelling piece that looks at the ways that this administration's firings and termination of employees has had in particular impact on Black women in this country, and highlights several, including several with whom I worked at the Department of Education, which is a deep dismay. And I'll just flag that in my role, my first role in the Biden administration, I was at the White House working on racial justice and equity in the Domestic Policy Council, and it was my job to make sure that there was a diversity equity executive order that first of all, when the president issued it, that it actually was public, and then that it was fully implemented. And that came from a recognition in the Biden administration that as good as our civil service protections have been, we still haven't welcomed in and then supported a fully diverse workforce in the ways that we could. And so it was a real effort in the Biden administration to make sure that we did, and that was the job of the federal government. So this is an about face that is partly about not having trust in whom our workforce is, but it's also partly about wanting to undo some of those gains that were nascent in that time. So I think that's worth our thinking about, and then thinking about what that means for democracy. What that means to have that much of an about face, and the senior most leadership in the White House signaling actually not all of us are welcome as federal employees, and what we want is a spoils system, and what we want is a narrower set of who can hold those jobs, and how we can have confidence in government. And I think that has real costs for us as a country too. But maybe we'll do a little law now, and you could talk about why you think that decimating those protections is a First Amendment violation, and also why it is against the system of laws that we have built.
Yeah. So before I get to the First Amendment argument, I think it's important to look at the legal argument that the Trump administration has articulated to justify what they are doing. Their argument is that Article 2 of the Constitution, which creates the executive branch, empowers the president to essentially control everybody who works in the entire executive branch. This is
an astonishing claim, right? Yes.
It's an astonishing claim. Yes. This is a theory that was developed during the Reagan administration by a group of young lawyers, two of whom are now Supreme Court justices, John Roberts and Sam Alito, who were looking for an argument to increase executive power, and they particularly wanted to increase executive power vis-a-vis other parts of the executive branch, the independent agencies, and some of the cabinet departments, where there is important work being done by civil servants that might not reflect the policy preferences of the GOP president, such as in the Department of Labor, the Environmental Protection Agency, the Department of Education. Empirical studies show that, by the way, that not all civil servants are Democrats, but that there is a tendency for people, even civil servants, to go to work in the cabinet departments that tend to align with their policy preferences. So you're going to see more Democrats in the Department of Education, because education, especially equity in education, is a Democratic, typically, political policy preference, labor, environmental agencies, et cetera. And you will see more Republicans in other departments that might be more aligned with traditional Republican policy preferences, perhaps transportation, building freeways instead of mass transit, occasionally State Department, et cetera. And so you do see some people leave government jobs, civil service jobs, when the White House switches hands if they find that their policy views are not going to be welcome. So you were a political appointee, and you're expected to leave on noon on January 20th when the new president, yes, required, right. But lots of people are not. But they will anyway, because they don't want to work for an agency that, especially at higher levels, that is pursuing policies that aren't why they got into public service in the first place. So there is some turnover that is responsive to the president, and the civil service law, as it was written, creates 4,000 political appointees in the executive branch, an organization that's tracking Trump's efforts to fill those political jobs has found that he's filled about 400 of them. They're not tracking all 4,000, but those exempted positions are supposed to give more political control, like positions that Catherine formerly held. Then there are other positions that are somewhat easier to remove. The senior executive service, which is a category that are civil servants but with less protection, that are supposed to essentially be the go-betweens between the top-level political people who come and go every 4 years and the civil servants who are expected to stay. So there is some accountability built into the way the civil service law was enacted, and some that happens just by practice, even though it doesn't have to. But the view of the so-called unitary executive doctrine is that's not enough accountability to the president, and that instead the president should be able to remove every head of an independent agency. That's all the people who've gotten fired from the National Labor Relations Board and the Merit Systems Protection Board and the Consumer Financial Protection Bureau, on and on, even though Congress, when it created those agencies, required by statute, that they cannot be removed except for cause, because the idea was to make them independent of the White House. And so the so-called unitary executive doctrine was about trying to make many people, potentially everybody in the government, more responsive to the White House. Until this Trump administration, nobody thought that that would apply to the entire civil service. I was a lawyer in the appellate staff of the Civil Division of the Department of Justice in the administration of George H.W. Bush. Guess what? I'm a liberal Democrat, and I always have been. Why did I go to DOJ? Because I was going to do technical statutory appellate cases about agencies that you've never heard of or policies that you've never heard of, because I'm a nerd and I like appellate work. Nothing political about it, and that was not unusual. DOJ was full of people like me where our politics were largely irrelevant to the job, because we weren't doing, at least in that job, policy work of any kind. And so, but they thought, the unitary executive theorists thought that it was essential to make anybody and everybody fireable at will by the president, from the heads of independent agencies right on down to staff attorneys at DOJ, or presumably, data analysts at the Bureau of Labor Statistics or typists. I mean, I'm not sure there are any typists left, but you get the point. And their idea is that Article 2, they say, and you can find it in Supreme Court opinions written by John Roberts, is the only branch of government that consists of one person. I think that's hilarious. First of all, poor J.D. Vance doesn't even rate. But also, what about the 2.2 million other people who make government work? And the boldest version of this argument is that democratic accountability, democracy as they think of it, necessitates the president to be able to fire and presumably hire anybody he, she, or they want to advance their agenda. That's their view of democratic accountability. We might see the Supreme Court accept that position in cases to be decided this term. The challenge, of course, is going to be whether there'll be any independence left. Will there be a nonpartisan civil service? I don't think they're going to go that far. They don't have a case that invites them to rule on that yet, but in theory, they could. So what's the matter with the Article 2 argument, apart from the fact that there are two other articles, branches of government, right? The argument is that, and this is the one that I make fairly briefly toward the end of the article, that even if you think Article 2 means that civil service protections, not to mention independent agencies, are contrary to the president's power to take care that laws be faithfully executed and be the chief executive, still, the First Amendment is a constraint on every branch of government. Article 1, Article 2, and presumably Article 3, as well as on state and local governments. And so the First Amendment, historically, has prohibited the government to fire people because of their off-duty speech on matters of public concerns. On-duty speech, like sitting at their desk, writing memos, that's the speech of the government and is not protected by the First Amendment under current law. But off-duty speech, speaking out on public issues, is protected by the First Amendment unless the disruption to the government's operations caused by the speech outweighs the benefit to the public of having government employees be able to participate in politics in their off-duty time, like vote, or to speak out on other matters of public concern. And although we haven't really had many cases about this lately, many people think that making party affiliation or loyalty to the current occupant of the White House a requirement for a federal job would violate the First Amendment as well, because it would essentially give, first of all, too much power to the White House in a way that's not conducive to good government, but for First Amendment purposes, it would constrain the ability of people to participate fully in the polity and to speak out in ways that are important. And so my view is that some of what has gone on in the Trump administration, for example, culling employees' social media to see who should be fired, which the National Security Council did a ton of even before Trump got into office, and reassigning any Democrat simply based on what they've said on social media violates the First Amendment. And I think the hard part is going to be that speech on the job has not fully been protected in the last 15 years since the Supreme Court changed the law. But think about the DOJ lawyers who got fired because they worked on the investigation and prosecution of the people who attacked the Capitol on January 6th, or the FBI officers who were involved in that. They were fired. They've been fired by the thousands. People who might have been involved in working on Biden administration issues in pick an agency, pick a cabinet department, firing them because of the work that they did for a prior government, simply because the current government disapproves of those policies, would require a change or an expansion of the First Amendment. But I think it's not beyond the pale to think that that expansion could come, because frankly, nobody wants a regular part of federal civil service to be, you worked on this issue, you work in the EEOC and you are involved in investigating companies that didn't get rid of their DEI programs, or now that, or whatever, eradicating non-gendered, gender-inclusive bathrooms, like, whatever. I happen to disapprove of those policy agendas, but I could accept that my party didn't win the election in 2024, and the thing to do is to change those policies in 4 years, or for Congress to legislate to make clearer what Congress's preferences are, whatever. But to have this sort of mass firings every 4 or 8 years simply because somebody worked on a policy, or somebody audited the taxes of a Republican, or somebody in the Bureau of Labor Statistics reported unemployment numbers that made the president unhappy, or fudged the employment numbers, but he liked it, and then they get fired in the next administration. Like, we need an orderly process to decide what is misconduct that should be a basis for firing, and what is doing your job as commanded by statute, by agency regulations that remain in force until they're repealed. And I don't think anybody wants a sort of a bloodletting of 1 million employees every 4 years. It's just chaos and a waste of money and regulatory power. And won't do, you want food inspectors to figure out where the botulism came from, regardless of whether the place that it was traced to is owned by a Republican or a Democrat.
I mean, you certainly want the food inspectors to keep doing that work. We also want the work of government to continue too, and that kind of chaos and also that kind of insistence on fealty to a particular notion or particular party loyalty will also stop the advancement of the work and stop public confidence in it too. So I really appreciate the broad explanation for the ways that those are harmful. I guess there's, again, a couple threads I want to pick up on in what you said. That one is when you're objecting to the loyalty test, I take it the objection is to loyalty to a president and not to loyalty to a country. And I've been thinking a lot about the national security clearances that I was interviewed for various people at various times, or just the security clearance just to be able to take a role. Those all ask a question about, or a set of questions about whether a candidate, whether somebody has a reason to believe that the candidate is disloyal to the country, or is subject to bribery, et cetera. And I always felt a little bit like, I don't know, like I have no way of knowing, somebody's income or the countries they visit and why, et cetera. Do you think that those are sufficient tests and necessary? Do you think that we actually, shouldn't have them at all? Are you drawing this distinction between country and person?
Absolutely, I'm drawing the distinction.
Yeah.
I think there's nothing wrong with requiring government employees to take an oath to uphold the Constitution and laws of the United States.
Right.
I did when I went to work at the Justice Department. And, the the security clearance process that the FBI runs can sometimes seem a little silly. When I was being investigated, they were super interested in knowing whether you smoked weed in college. And it was sort of conventionally known that you could admit to having used a little pot in college, but not in law school. And when the FBI was talking to me, they said, and I'm not a big lover of weed, I prefer wine, but you do you, I really don't care. But I was like, sure, I tried it in college, and the FBI agent said, and who was there? And I just started laughing. I was like, oh, you can't seriously expect me to tell you. And he said, well, but you must. And I said, well, I don't recall. It was college. It was a long time ago. I almost started to say, and we got stoned. Like, of course I didn't remember. It was kind of silly exercise. I don't think they were actually effectively finding out whether I was a mole for the Soviet Union in the late 1980s, or whether I was likely to bomb a federal building or any of that. So I would say that it's perhaps not the most effective process, and often it was used for really wrong purposes, like trying to ferret out whether people were gay or lesbian. But in principle, well administered, there's nothing wrong with it. Loyalty to the country, though, of course, is radically different from personally loyal to the policy agenda of the person who won the last election. There were at DOJ political people above my level at the Justice Department, and I was told in a couple of cases to make a particular argument that was important to the Republicans who were at the very top level of DOJ at the time. And I got summoned to a meeting and said, you need to make this argument in this case. And I said, well, I think that argument is not the strongest argument that the United States has in this case. I think we'd be better off with a statutory argument. And they said, well, we have decided that you need to make that argument. And I said, okay, I will make that argument. And then when I got out to argue the case in the Eighth Circuit, I was trying to make that argument. And the panel of judges absolutely were not having it. You could just see them going, counsel, are you seriously saying? I was like, well, this is not working. And, I quickly said, Your Honor, you could rule for the United States without regard to that argument by focusing on subsection 26B whatever of the statute. And they were like, yes, counsel, let's focus on that. And that's the issue that we won on. Like, I had to do my job, and on some things, I didn't like some of the arguments I had to make, but fine. They won the election, I get it. But that's a very different thing from violating the law simply because the president chooses to change the law by fiat or by just non-compliance without legislation enacted by Congress and signed by the president. And so, the loyalty that they are demanding in some cases now, like the loyalty programs that Catherine referred to earlier from the late 40s and early 50s that required as a condition of having a government job that you answer the question whether you had ever been a member of the Communist Party, is irrelevant to the ability to do the job. Government lost a lot of good employees, either like my mother, because they thought she was a communist, even though she wasn't, but they never bothered to ask her, actually, they just fired her, or by people saying, I will swear my loyalty to the United States, but I won't swear whether I was ever a Communist Party member. And losing good employees because they joined a radical party when they were in college. I mean, heck, when I was in college, I was a big admirer of Karl Marx. If there'd been a Marxist party that made any sense, I might have joined it. Later I developed somewhat more sympathy for socialism as opposed to communism or whatever. It's not relevant to my ability to represent the Federal Aviation Administration in some complicated case about whether to ground a small, air freight company in Texas, one of the cases I did. And so I think that there's a well-established difference that's existed for the entire history of the Republic between loyalty to the Constitution and laws of the United States and loyalty to this particular person or party.
So also you talked about what you were worried about when you started writing this, and that it was going to be an op-ed, and then it became an article because of the excess and the degree of harm. But it's really notable to me that in the time since December, when you started thinking about it, to when you published, which is this fall, to now, that we've seen so many iterations of different ways that the incursions on what that civil service have meant are. And if you wouldn't mind talking about some of the things that you describe in the article as what you're worried about, and maybe we can step beyond that to what has happened since, too.
Sure, yeah. So it began on January 20th with an executive order that they had obviously teed up that was to allow the president to essentially, or the Office of Personnel Management, to reclassify a whole swath of civil service jobs as being accepted from the civil service because they involve policy making. And this was something that Trump had tried at the end of his first term in office, didn't implement. And so that was their first move. But reclassifying jobs so that then people could be fired is a relatively slow process. And so then they did more things. As you know, Elon Musk came into government to be actually not the head, but he was sort of involved with an entity that was renamed the Department of Government Efficiency, DOGE, but in fact had previously been an agency that was about updating IT systems, essentially, to enable a better rollout of the Affordable Care Act, Obamacare, and to sort of move it into the White House in order to enable a bunch of people who previously had worked for Musk-owned companies, Tesla, SpaceX, to go in. And I know there are people in this room who encountered the muskrats, as I call them, in following something that some civil servants said in jest. This is little Dojites with their clipboards who would sort of come in and try to get rid of civil servants. There was mass layoffs of probationary employees by the tens of thousands, partly perhaps because it's easier to terminate a probationary employee, although they can't be removed for political reasons, which maybe they were, and they can't be removed for no reason. Rather, probationary employment in the federal service is considered a further opportunity after the hiring process to assess whether the worker is a fit for the job. Do they have the skills? But they didn't try to do that. They just laid them off by the thousands and thousands in disregard of civil service law. They then, this happened in a variety of different ways. They tried to roll out a new exception from civil service protection, different from the one they announced on day one, which was for policy-involved people. This one was just to allow political appointees to be put at any level of the civil service, called Schedule G. So they did that by executive order. And they're trying to do these schedule exceptions to the civil service through rulemaking now. I suspect the policy career exception those regs are gonna come out or be finalized any day. So they did that. They eliminated summarily collective bargaining rights for federal civilian employees by executive order. can't really do that because collective bargaining rights are written into the civil service law, but they kind of expanded and invented an exception for people whose jobs involve matters of national security, and then proceeded to declare that almost every cabinet department, including Veterans Affairs, the Department of Interior, which manages, federal lands, involved national security, and really the only federal employees who didn't lose collective bargaining rights were those engaged in actual law enforcement, the people like the Marshal Service or various kind of people, the people who actually had something to do with security. So elimination of collective bargaining rights. There's more, just summarily firing people for no reason. And all of that was essentially, I think, in part to get rid of people that they thought might not be sympathetic. Probationary employees are people in their first year or two on the job. I think they might have imagined that they are sympathetic to the Democrats because they started their job in the Biden administration, although many probationary employees actually had been in other government positions like the military, not necessarily Democrats. So some of it might have been, guessing about people's political views. Some of it was because they'd worked on something that attracted somebody's attention. Some of it is just, I think, frankly, about fear. The idea that we will be able to get loyalty of remaining government employees if everybody who has a mortgage or has a non-working spouse or no spouse and is worried about running out of money is afraid to lose their job. They will just keep their head down and do whatever they are told. Prosecuting the president's political enemies is an example. And so one of the things that's been interesting about this is, although some people who were part of this process had real experience and expertise with the federal civil service and were doing this in the sort of let's issue new regulations and try and narrow the range of civil service, others, which could be done, although it's complicated how it would fit with the statute, others of it was just let's just do it and worry about whether it's legal later. And there's been, as you may know, hundreds of lawsuits filed challenging this, many brought by government employee unions, which of course now are in a very vulnerable position financially because they no longer have employees to represent because collective bargaining rights were eliminated and people can't pay dues because they're not getting paid a salary, et cetera. But lots of these lawsuits were filed by the unions trying to protect the civil service system. And generally speaking, both because the lawyers were careful about where they filed and filed in front of, in courts where they thought they would get a good judge. In some cases, they got judges who were appointed by Trump from his first term who were appalled by what was going on. So a lot of these initiatives were enjoined, but as you may also know, they promptly appealed those, and the Supreme Court stayed the injunctions in many, many cases, and hence lots and lots of people lost their jobs. And so, almost the entire Department of Education has been eliminated, which can't legally be done, but it's just happened, and the Supreme Court stayed the lower court decisions restricting that. And so I think that they're sort of thinking they're just going to move fast, break things, and they'll see how much progress they can make.
Yeah, I think that's exactly right. And I do want to leave a little bit of time for questions, but I'm going to just offer one other example of what the risks are, and we've described them as these are the kinds of things that could happen, and they sort of feel increasingly jaw-dropping. And what I found really shocking was that at the U.S. Commission on Civil Rights, which I used to chair, and it's in statute bipartisan, one of the Republican appointees on the commission refused to vote for President Trump's selection for who would be the new chair for the U.S. Commission on Civil Rights, who's a friend of hers, and which she said in this transcript that's been reported in the news, because she had heard that the White House planned to withhold funds for all of the Democratic appointees on the commission's staff, but only the Democratic appointees and not the Republican appointees. And because she hadn't received assurance that they would not do that, she wouldn't vote for the president's choice, which is an astonishing thing to put on the record, an astonishing thing to have heard and then to have failed to hear assurance that it wouldn't happen, to the point that the president's choice isn't the chair. There is no chair now as a consequence, because that leaves at least the pregnant inference that is what the White House is planning to do. And so that, as we think about the kinds of things that could happen absent these core protections, they become more and more extreme, as the days go by, and it is quite astonishing. So, in our last minute of our talking, and then the hope that if folks have questions, they'll ask them, and maybe they have opinions about this also. But I'd love to hear from you, if you have thoughts about what it would take following this time to have people have confidence that there are good government jobs, and that they could go back, they could go into government service and expect to stay past a single presidency.
Yeah, I think it's going to, I'm an optimist, an incurable optimist, so I believe that it will get better. We've come back from terrible things before. The McCarthy era, which was much longer than the tenure of Senator McCarthy, the Nixon efforts. And so I think that if the next president makes a renewed commitment to bringing back federal civil service and the federal civilian workforce to even better than what it was. There were problems with the pre-existing system, as anybody who's worked in a large bureaucracy knows. Sort of, let's use this as an opportunity to reform what needs to be reformed, but to bring back what worked well. And then I think, I would encourage young lawyers to go in and take those jobs. Rebuilding the Department of Justice is going to be a huge project, but it happened after the Nixon catastrophe. It can happen again. Rebuilding all of the agencies and cabinet departments that do really important work, the Consumer Financial Protection Bureau, et cetera, it's going to be more important than ever to get really good people who are mission-driven and also, inspired by the idea that we're going to rebuild this. And maybe Republicans will win the next election, but we will build a good system to hand over to them at noon on January 20th. And they're going to change our policies, but they're not going to wreck the government again. And that's what I'm hopeful about.
I like that note of optimism. And I'm going to see if folks have questions or comments on. Go ahead.
Hi. I was wondering, since we had recent news that the Ninth Circuit upheld kind of hesitantly, but they upheld the constitutionality of removal protections for ALJs in the NLRB. And I was wondering if you had any thoughts about the specific effects of getting rid of those removal protections for ALJs and how that would impact.
Yes, and you should talk to David Rosenfeld here, who knows a lot about that case. Getting rid of removal protections for administrative law judges, whether in the NLRB or anywhere else, could be very concerning, let me just say, if the reason it's being done is so that the president or his flunky in the White House can hear from a company that's currently the subject of a proceeding who says, God, I really don't like the way that ALJ, ruled on that evidentiary objection in the middle of a hearing. Could you get rid of them? That would be a denial of due process, among other things. And so I don't think anybody thinks that ALJs should be subject to removal for political reasons. There is a process for removing them for misfeasance, for cause. But for political reasons or because they ruled this way in this case or on this evidentiary objection raises some serious questions about due process, among other things. What's gone on in the National Labor Relations Board is that the Fifth Circuit ruled that the absence of removal protections, the absence of the ability to remove ALJs means the National Labor Relations Act, in its enforcement mechanism, violates Article 2, and they enjoined the enforcement of the National Labor Relations Act in the Fifth Circuit, which is Texas, Louisiana, and Mississippi. And the government wouldn't even defend the constitutionality of the statute. So there's they're trying to figure out how to get that decision overturned. The Ninth Circuit, or some others, there could be a conflict on this issue. I'm collapsing a variety of complicated issues and boiling it down. But if most courts who had ruled on ALJ's protection from removal had held it's abstract to say that the statute can't be enforced in your case, because there's no evidence that the president wants to remove this ALJ. So it doesn't violate Article 2 for this ALJ to handle this case, because for all we know, the president's perfectly happy with the ALJ. This challenge is not ripe, go away and come back if the president says, I want to fire this person and I can't. And so, that could be the way that this issue would pan out, is on the procedural question of only if the president tries to fire the ALJ and can't, would there be a challenge to the constitutional structure of the statute. But the NLRA is always the favorite target of conservatives who are looking for a major New Deal era statute to get declared unconstitutional.
So we are at time. I really thank everybody for coming, and I also hope that others will go into government service as we are ready to build. I so appreciate your sharing your expertise and your knowledge, and really want to be grateful to the folks who have been in federal service for the work that you did too. Thanks very much.
Thank you.